Like almost a year.
Almost a year, yep. It's good to know. Janet?
Ours was 5 months in Florida.
5 months in Florida. Florida's a little easier than Georgia. So probate is a court process to validate a will, if there is one, and make sure that it's a legal will, because not all of them are, and that the creditors get paid, and that the beneficiaries that were named in the will get their proportion correctly. And so it's what I told you before about, okay, so we can't sell anything, we can't give anything away until we get to a certain point and get those letters of testamentary or letters of administration. It can be sold then, the proceeds go to the estate. It can't go to the executor or to the beneficiary because they can't get it yet. Bills have to be paid before they get their portion. Probate math. These are all the different steps that a family or an executor has to go through when they go through probate. So you could see that does not look easy. These are the major steps, and there's 14 different ones. The place that it starts, of course, after you contact us, or if you want to do it by yourself, which a lot of people try, then is to secure the assets. So you guys might run into this in that, so someone passes away, and what happens is other people that are able to get into their house that gave them something come back and take it. So usually within 24 hours after someone passes away, people start taking things from their house. And the next thing you know is like, oh my God, where did this stuff go? You don't know who took it. They're not allowed to take anything. So as the executor, the first thing that you want to make sure someone does is secure the house. I like to have people change the locks on the house so that anybody that had a key can't get back in. And I don't think they're truly trying to steal anything, but what they are trying to do is get things they think belong to them. And at this point, nothing belongs to anybody. So when you're in the middle of that, but the next very fun thing that happens is there needs to be a petition written on the form that the court has and sent out to all of the different beneficiaries and heirs. They need to sign it, witness, notarize it, and send it back. That's where problems start, because there's always somebody that said, no, I'm not signing that. Nope, not going to do it. Don't like you people, don't want you to get the inheritance, not going to happen. And then what do, right? So you have to keep trying to get them to sign it. The family feuds begin, and you end up having to get them served through the court. And so that just takes longer. And 6 to 9 months is best case scenario. That's not when the courts have been closed for a year or anything like that, they've got a backlog. 6 to 9 months is the best case scenario.
And that's with the extended power.
Mm-hmm. Or not selling anything while it's in probate.
So if you have a client that dies and the life insurance or whatever hasn't kicked in yet, and the heirs cannot pay the mortgage, would banks work with them to wait until they sell the house?
I'll tell you, every bank is different, so it would depend on the bank. But some do and some don't. Let's say that I bought my house and I paid $50,000 for it in downtown Woodstock back in 1970. And now that same house is worth $500,000. So if I were to sell it, I have to pay capital gains on that $450,000 or use this one specific IRS exemption so that I don't have capital gains. But if I gave it to somebody, I didn't sell it, I gave it to them, they have to pay the capital gains on $450,000. But when I die, my beneficiaries take it at that $500,000 mark. So when you see people giving their house to their children to try and protect it, it's usually not a good idea for a multitude of reasons, but that's one of them. Because they can have a lot of capital gains, where if you get the house because you inherited it, you take it for what it's worth at that time, but you need to get it appraised so you know what it's worth. Especially if you're not going to sell it for another year or two. And the way the market has been the last year, you could really have difficulty with it. Another thing they need to do is open an estate with the probate court. So you guys can't sell it until you get those letters, and you have to go through the probate court to get those. All the personal property and stuff that's in the house, there's a few ways that can be handled. Some of the older wills, they've got, like this goes to Aunt Susie, and this goes to Cousin Benny, and all of those kinds of things. But most of the newer wills, they might have a few special items that they leave to special people, like the wedding ring or something. But everything else in the house just gets divided amongst the kids. The kids go in and work it out. Most of our kids don't want our stuff anymore, so they just give it away. But if they do want something, they can decide to take it. It is a real scary area that I think executors don't know is, so when I pass away, if I have a mortgage on my house, somebody has to continue to pay them. But they can't get to my money in my estate because it's tied up in probate. And so they have to somehow find that money to pay the mortgage, the taxes, the insurance, and at least minimal utilities. So my brother passed away about 5 years ago in an accident and did not listen to his sister and didn't have his stuff in order. No surprise, right? And so we were 4.5 years going through probate where we couldn't even sell his house for 4.5 years. So we were having to pay all of that until we could get his house sold last December 31st. What a great day that was. But executors might not know that, and what happens is, if the house doesn't keep continuing to get paid for, it goes into foreclosure. So they will foreclose on a house while it's in probate. You want to make sure if you're selling a house or talking to someone about selling a house, that you're dealing with the executor. So I don't know about you guys, but we get a lot of family members that call and they think they have authority, but they don't. Only the executor has the authority. So if somebody else calls, they have legal authority to do nothing. We don't really want to spend any time with them because they can't do anything. So you want to talk to the person that has the power, which is only the executor. Anything that you have a beneficiary on bypasses probate. When you bypass probate, the creditors can't come after it. But if you have a beneficiary on a 401k, an IRA, anything, life insurance, it goes around and circumvents probate. Yep. And if it goes through probate, they should, funeral homes are one of the top payers. And what happens is the executor, if they don't pay them in the right order, then what happens is they are personally liable. But if that life insurance was $5,000, they might have spent the whole $5,000 on attorney fees and court fees before they ever got to the funeral home. So there might not have been anything left for the funeral home, and that's why they're coming after you guys. In the state of Georgia, you are not responsible for your relatives' bills. Yay! Right? You're not even responsible for your spouse's bills. So if my husband has a credit card that's just in his name and he's got $20,000 of debt on there and they want to come after him, they can only come after his stuff or his half of anything joint. But if he dies and we don't have to go through probate, they don't get paid and they can't come after me.
Wow.
It's a beautiful thing.
Let's make an appointment tomorrow.
Exactly. So there's a lot of advantages of avoiding probate, and we'll talk about them a little more. But another one is hospital bills. So I had a guy that came in just yesterday. This one, I get some of them that really break my heart. I hear a lot of bad stuff every day, but typically, you know, I don't think we've ever met somebody we can't help and make their life better, so that always makes me feel good. And this guy can make his life better, but he's gotten what I call a pretty fast curveball. So he's 62 years old and he got diagnosed with prostate cancer. Prostate cancer is something that is so curable as long as you get it checked. I guess he didn't, and I didn't ask about that, but he's in the final stages, and they're saying that he's got 18 to 22 months to live. And so he lived up in northern Ohio, but he had a daughter here. The daughter says, oh my gosh, you need to sell your house and move down here. So he did, thinking he's going to need a lot of care. He's in chronic pain right now. I mean, you could tell it by looking at him. So at 62, he comes in and he said, you know, is there any way that I can protect my life savings? I don't have that much, but I've got some money from selling my house. And so what he's worried about is that he doesn't have good enough insurance to pay for his care, you know, even with the doctors, and that the medical professionals will stop paying for him or stop giving him care. And he's worried about, like, now that he got here, his daughter's so busy with her family. She's what we call the sandwich generation. She's got kids in high school. She's got now her dad living with her. She's got her own career. The husband's got a career. So none of them are ever home. And he's thinking, like, why did I come down here? Because you people don't have enough time to take care of me or even see me. So he's worried about those two things. And then he's worried about, like, anything that he did save, that he's going to lose that to the hospitals. And so that's where a trust comes into play. And I can put all of his assets, except for his income. So I want to leave him with his income and with some money so he can pay his bills. But I can take everything else and put it into a trust, and it's protected. So no matter what, we've had a lot of people that have run up $1 million more at the hospital. You don't have to pay that when you go. You might have to go on a $10 a month payment plan so that they continue to treat you, but you don't have to give them everything you worked your whole life for. So he was really happy about that because he had been staying awake at night worried that who was going to pay for his care? How was he going to get the care that he needed in the next 18 to 22 months? So we were able to help him with that, but also then help him to have something he wanted to give to his grandchildren after he passed. And we told him some ways. We don't deal just in the legal realm. We are very connected with the senior industry all around Cobb, Cherokee, Paulding County, and so I was able to give him some resources that can help him when he needs more help to come into the house or to do things for him, and even some cost-effective assisted livings, because now he's worried that he's going to ruin his daughter's life, that he moved down here and she's not going to help him. So he could afford to go to an assisted living, and then he's not a burden on the daughter. They'll drive him to doctor's appointments. They'll feed him, you know, good food all the time and take good care of him. So we're more holistic than, you know, here's just your power of attorney type of thing. And a trust is a way to do that. But many people still think that you have to be a multimillionaire before you need a trust. Think of a trust as a treasure chest. And in that treasure chest, let's say that it's my trust. I can put things in that treasure chest that I want to protect, or things that I want to avoid probate court. A lot of reasons I might put things into this treasure chest. But let's say I put some of my money in the treasure chest. I always want to put real estate in the treasure chest. The reason for that is it's very difficult to make real estate go from one owner to a different owner without it being in a trust or going through probate court. So in my trust right now, all I have is real estate. And I might later put other things in there, But if I were to die today, I have everything set up, so it's all going to go to the trust and avoid probate court. And that's what we help our clients do. But let's say that, I have this money, so I'm the grantor. The grantor is the one that owned it before it went into the trust or the treasure chest. There's also a trustee, which is a manager. They have a key to the treasure chest. Sometimes that could be me, sometimes it can't, and I'll tell you the difference. And then there's the beneficiaries, the ones that are going to get everything in the treasure chest at some future point in time. I could be the beneficiary as long as I'm alive. So if I put my house in there, that doesn't mean that I don't get to live in the house, that I don't get my homestead exemption, that I don't get the school tax, that I don't get some IRS exemptions, etc. I live in my house exactly the same way as I did before it was in a trust. No change. No magic trust fairy that comes around and pays all your taxes, insurance, maintenance, and utilities and that stuff. You still have to pay it. But if you want to sell your house that's in a trust, you can do that. The trustee just goes to the closing. So I used to live in Woodstock because the office, I opened it in Woodstock. I am now in a 3-mile perimeter to where I work. We're not going to commute anymore. I know you guys drive around all the time. You probably don't understand it, but I'm old. So when we opened up the Marietta office, it's like I got to move to Marietta because I'm outside of my 3 miles. So my trustee had to go to the closing, sign the closing papers for the one house, and sign the closing papers for the other house. I didn't even have to show up. My trustee does that. So I thought that was an advantage of it. But if I wanted to take the money out, let's say I didn't want to buy a house. Let's say I just want to sell one house and take the proceeds and leave those in the trust. I could do that too. And then those assets are protected. And if I wanted to, let's say I did want to move into an assisted living, my trustee could use this money to pay for me to go to the assisted living. Or let's say something more fun, I want like $10,000, I'm going to go on a good vacation. Now if I go to my trustee and I say, hey, I want $10,000, I'm going to go on this vacation, and my trustee is my son, and my trustee says, oh, Mom, you don't need to do that. You don't need to go on a vacation. You don't need to spend that money. You need to save it. You're fired. I can get rid of that trustee at any point in time because it is my money and I get to do what I want, whether they agree or not. And I'll put somebody else in as the trustee. So you've got the grantor who owned things before it went into the treasure chest. You've got the trustee who manages the treasure chest. And then you've got the beneficiary. So with my trust, as long as I'm alive, I'm the beneficiary. Everything in there is for me. Is that clear? Okay. Now, there's 2 major types of trusts. And you need to know this if you're going to sell real estate that's in the trust. Yes?
I guess the trustee could be both the trustee and the beneficiary.
Could be.
Yeah.
Could be the grantor, could be the trustee, and all the beneficiaries. All 3 of them. All right, 2 types of trust. One is called a revocable trust, also known as a living trust. The other one is irrevocable or asset protection trust. The living trust does not protect assets, and you could be your own trustee for the living trust. So what's the advantage of having a living trust if you're not going to protect assets? One is you avoid probate court. Woohoo, right? 2 is your beneficiaries get to your money and your assets as soon as they get a death certificate. How sweet is that? I mean, you don't want to wait 9, 10 months, 4 years, or whatever. You can have some control of your assets even after you pass away. Let's say that I pass away. I want to make sure that if my husband remarries and then they get a divorce, that the new ex-wife doesn't get part of what I've worked my whole life for. I can control that. I can also control it if my husband gets into, let's say he takes up gambling and he gets into a lot of debt, or maybe he gets sick and runs up a bunch of medical bills. I can protect the inheritance from that even after I'm gone. So there's things that you can put in there that will protect it. Nowadays, we have a lot of us that are in second marriages. So we've got the blended family. And you want to make sure, typically, that you bring your kids, he brings his kids, that somehow your kids still get some of your money. You don't want it to go to your spouse, and then what happens, your spouse remarries, spends all of your money on the new family, and disinherits your children. You can do that in a trust. In a will, the day you die, everything is done. It happens to be solidified that day. It can't change after you die, but with a trust, you can make things happen after you die. So that's pretty amazing. You can also protect anything your children inherit from creditors or from divorces or lawsuits, which we want to make sure that, they get to use it somehow as well. If you have anyone in your family with a disability, so we've helped over 3,000 families. It's not uncommon for someone to have someone with a disability in their family. If someone is getting some type of government benefit because they are disabled, like Social Security disability, and all of a sudden they inherit from you, they get kicked off of their government benefits until they spend all of your inheritance down to $2,000. Well, you don't want that to happen, so we protect that. There's a way to do that. Closing attorneys are great, but they usually start working on this stuff a few days before, and so they need to know early when there's a little something different, and trusts usually throw them off a little bit. The next thing you need to know is, what kind of trust is this? And you can usually tell by looking at what's called the Certificate of Trust. It's a one-page that says everything anyone needs to know about the trust. What tax ID it's under, who's the trustee, what's the name of the trust. If it's a revocable trust, it'll say it's a revocable or a living trust typically. If it's an irrevocable trust or an asset protection, it will say that. So if you get the Certificate of Trust, which is number 2, you want to get that. Number 3 is who has the authority and what kind of trust. So it might be, for example, when I sold my house, I got in touch with a realtor. Now I could talk with the realtor, but in signing the contract for the realtor, my son needs to sign it because he really is the manager of the house. But I could still tell the realtor how much I want to sell it for, the terms, blah, blah, blah. I get to accept the price and the terms, but my son has to be involved in signing things. So you just want to know if there's another person that you have to bring into the circle so you can get things done and you're not trying to track them down. The trustee isn't always around you. Then you need to make sure the trustee's going to be there for closing, or you've made provisions for the trustee to sign at closing. And then the final thing is that the proceeds from the sale of the house need to go to the trust. They don't go to the grantor, the people that owned the house before it went in the trust. They can go to the trustee and the trust, because the trustee has to sign it or whatever. We don't write checks for that anymore, it's wired, but it needs to go into the trust. Now, one of the things that we frequently get calls from our clients about is a property is in a trust, and a real estate attorney wants to take it out of the trust to sell it and then put it back in the trust. You don't want to do that, because if I'm looking at this 5-year Medicaid look back, so I'm not covered for 5 years, if I take that thing out, I restart the 5-year clock. That could be devastating to me. So I don't ever want it taken out. So we tell our clients how to get around that and help them with the closing attorney, but I just want you to know that that's not something that you want them to do. So not all realtors are made the same, and not all lawyers are made the same. So you need to, of course, I'd love for you to come to us, but if you don't, go to somebody that really is in elder law, if this is what you want to do, because people that practice other types of law don't really know this, and there's a lot of complexities in this type of law. And there are people that we call door attorneys. I don't know if you've ever heard of that before, but door attorneys take whatever walks in the door because they need to keep the lights on. So they're not really experts at anything, or maybe they decide to do this and this and this. They're not really experts. Just like when you have a real estate attorney, you've got one that's what they do. They got the processes, they got the people, it's all a well-oiled machine. That's what you're looking for in any kind of law that you want a lawyer, is somebody that focuses on that so they can keep up and do the right thing. If you've got something that you just put some money down on a house, you better protect it, because you never know when it's going to come to you. Those curveballs keep coming to every one of us. It's just life. And so if you're prepared for that, you're going to feel a lot more comfortable that the people you love are taken care of.